1,800 lakes. That's how many of our state's waterways may be impacted by a lawsuit just filed in federal court. It looks to overturn a law Governor Whitmer just signed that those opposed to say infringes on their constitutional rights.
Senate Bill 662 basically says we don't need to care about what anybody else thinks. We only care what the government thinks.
As an attorney, Philip Ellison often finds himself standing up for clients who he believes have been wronged.
Well, it's usually at the intersection of property and where governments are doing unpleasant things to those properties.
And he and his clients believe this, just signed into law by Governor Whitmer, is one of those, in his words, unpleasant things. So they filed this lawsuit in federal court.
The lawsuit is asserting what's known as procedural due process, a 14th Amendment right that property owners have to continue to benefit from property rights that have already been previously established under Michigan law.
All of this has to do with how much water is out there in Higgins Lake.
100 years under Michigan law, counties that were assigned certain responsibilities on certain lakes of certain sizes had to maintain those water levels at a very specific point.
If this sounds familiar, it's because it's been an issue for years. Some property owners claiming the county wasn't holding up its end of the bargain in keeping lake levels consistent.
They established what's called an entitlement, meaning it is a right to the continued maintenance of those water levels at that level.
But homeowners say the level, established more than 100 years ago, wasn't being maintained.
Over the last couple of years, about 10, 12 years or so, Roscommon County has said we don't really need to follow that law anymore. So we actually sued on a group of property owners.
And in 2022, they won, which the homeowners felt meant situation resolved until this came along.
When the legislature came back in and said, we're just going to change that, and we didn't give anybody the chance to come in to say why that water level should be adjusted, which we call in the business notice and the opportunity to be heard. When you didn't give people that opportunity for each individual lake going forward, that violated the Constitution.
Ellison argues Senate Bill 662 lowers the obligations of counties to maintain the established lake levels by redefining what the normal level is. But by doing it the way this allows, it removes the due process of a property owner granted in the 14th Amendment of the Constitution.
So it's not that levels of lakes can't be changed. It's the process. Give everyone a fair shake and an opportunity.
Homeowners have filed suit again, and Ellison hopes to be headed back to court to get things back to the way they were. He says while this case centers around Higgins Lake, the law and the potential ruling of the federal lawsuit will impact the more than 1,800 Michigan lakes that have lake orders that are regulated.
What we're asking, in a nutshell, is to the federal judges, go back to the way it was before. And if a county says they can't maintain a level as the local court order tells them to do, they've already got a process. Change the level. But you don't get to change the level arbitrarily. You got to do a notice and a hearing and an opportunity for everyone to have a fair and open chance to say what that level should be.
Ellison and his clients are waiting to see if the federal court will provide some relief and restore the former standards. In the meantime, the recently signed law will determine the obligations and responsibilities for those who control lake levels.